Welcome back, everybody, to the Law of the European Union. The previous few lessons had been taking a brief introduction to some of the basic concept of the European Union, looking at the historical development, looking at the process of joining the European Union, and then finally ending on the process of leaving the European Union. This lesson is going to introduce the next of our major topics, which looks at the institutions of the European Union, as well as the process of lawmaking within EU law specifically. In this first lesson examining the institutions of the European Union, what we're going to do is spend some time looking at the different structural components and parts of the EU from what I've described here as something of a generalist perspective. And the idea here is to take an overview of the various institutions of the Union as a way of being able to then start to unpack these institutions in more detail as time goes on in future lessons. So, ultimately, the European Union began arguably with the Treaty of Rome and the European Economic Community back in 1958, and was a relatively small collection of institutions. It then grew into a number of collective institutions, all of which have their own functions, purposes, and powers. And it is the purpose of this series of lessons, this second chapter, to talk about the collective institutions in their detail and to talk about the various different functions and powers that each of them have and the ways in which they contribute to the creation of not only policy within the European Union, but also EU law. The different institutions of the European Union, I apologise, are defined and outlined specifically in Article 13 on the Treaty on European Union. And Article 13 of the TEU says the following. It says that the Union shall have an institutional framework which shall aim to promote its values, advance its objectives, serve its interests, those of its citizens and those of the member states, and ensure the consistency, effectiveness, and continuity of its policies and actions. The Union institutions shall be, and then it starts to list the Union institutions, and they are listed as follows. The European Parliament, the European Council, the European Commission, hereafter referred to as the Commission, the Court of Justice of the European Union, the European Central Bank, the European Court of Auditors. So, a couple of things to note straight away. You have two different councils within the European Union. Interestingly, there are actually three different councils in Europe because the Council of Europe, being a separate institution, also exists. But sometimes you can refer to the council as the Council of the European Union. Sometimes it is better described in that way. So you have the European Council and then you have the Council of the European Union, which are two different institutions. The Court of Justice of the European Union also has its own subsidiary court structure as well, which we will get to when we talk about the ECJ in more detail. The European Commission is often referred to as just the Commission, given that there is only one of them. And then the two final institutions on this list are not going to be covered in this series of lessons because they're not necessarily too relevant, only for when we talk about European financial law and the way in which European monetary law operates, will we talk about the European Central Bank. But for the most part, we're going to talk about the Parliament, the Council of the European Council, the Council, Commission, and the ECJ in more detail. Part 2 of Article 13 says that each institution shall act within the limits of the powers conferred to it in the treaties, and in conformity with the procedures, conditions, and objectives set out in them. The institution shall practice mutual sincere cooperation. We will get to what sincere cooperation means in the future, but Part 3 says that the provisions relating to the European Central Bank and the Court of Auditors and detailed provisions on other institutions are set out in the treaty on the functioning of the European Union. The European Parliament, the Council, and the Commission shall be assisted by the Economic and Social Committee as well as the Committee of the Regions, acting in an advisory capacity. So, essentially what this means is that when we go to looking at each of the institutions individually, when we do a lesson, for example, on the European Parliament on its own, we're going to have to then go and jump to the Treaty on the Functioning of the European Union to outline the competences, the powers, and the procedures that exist within the European Parliament and the Council and the European Council, etc., etc. Now, I want to finish this introductory lesson by just discussing briefly the importance of the European institutions. because arguably students of EU law ought to be really and most familiar with these three institutions: the Parliament, the Council of Ministers, and the European Commission. When it comes to the process of making EU law, the lawmaking process itself, as we will see as time goes on, these institutions are incredibly important for our understanding. Law students will also have to be incredibly familiar with the Court of Justice for the European Union, sometimes described as the CJEU, or sometimes just described as the ECJ. Often we go for the former rather than the latter these days, because it is actually formally described as the Court of Justice of the European Union, rather than just the European Court of Justice. This is where we're going to find the majority of our case law on the matter of the European Union. And so, for the most part, these are the four institutions that we're going to have a lot of time and spend a lot of time examining in more detail. Welcome back, everybody, to our studies of the law of the European Union. We're continuing talking about the various different institutions of the European Union which are of particular relevance to our studies as lawyers in understanding what the European Union actually is. We took a brief overview in the previous lesson on the various institutions of the European Union as established by the Treaty on European Union. In this lesson, we're going to start to talk about the first of these major institutions in more detail. We're going to talk about the European Parliament. So, the previous lesson, as I mentioned, we talked about the ways in which the European institutions are established by Article 13 of the TEU, the Treaty on European Union. And this lesson, like I said, is going to examine the first of these, looking at the role, the powers, and the functions of the European Parliament. So, one of the things that is important to note about the European Parliament is that it is the only institution within the European Union that is directly elected by the citizenry of the member states. You will have European parliamentary elections at very regular intervals if you are a member of the European Union, if you are in a member state that is a part of the European Union. Now, the main functions of the European Parliament involves holding to account the Commission as well as holding to account the President of the Commission, both of which are very important roles for the establishment of democratic legitimacy and accountability within the Union itself, within the Union's political system. Now, the formal codification of the rules and powers of the European Parliament are outlined in Article 14 of the TEU. So if we look at the Treaty on European Union, specifically Article 14, it says the following. It says that the European Parliament shall, jointly with the Council, exercise legislative and budgetary functions. It shall exercise functions of political control and consultation as laid down in the treaties. It shall elect the President of the Commission. This is one of the main methods by which it holds the President of the Commission account. It elects the President of the Commission. The European Parliament shall be composed of representatives of the Union's citizens. They shall not exceed 750 in number, plus a president. Representation of citizens shall be digressively proportional, with a minimum threshold of 6 members per member state. No member state shall be allocated more than 96 seats. So this is essentially talking about the ways and the methods by which we see representation being established within the European Parliament itself. It is done on a proportional basis. You have the smaller member states having less seats, and you have the larger member states having more. But there is a minimum and a maximum threshold that is established by this particular provision as well. The minimum threshold is 6 members per member state, and the maximum threshold is 96 seats per member state as well. The European Council shall adopt by unanimity, on the initiative of the European Parliament and with its consent, a decision establishing the composition of the European Parliament, respecting the principles referred to in the first sub-paragraph. Part 3 says that the members of the European Parliament shall elect for a term of 5 years by direct universal suffrage in free and secret ballots. So this is essentially talking about the term limits for members of the European Parliament. You have a term of 5 years. It is done through an election, which is a free and secret ballot, which is representative of the elections to the citizenry, and is also done through universal suffrage. So we're not going to limit the ability for individuals to actually to vote on the basis because of various characteristics and discriminatory principles. Part 4 says that the European Parliament shall elect its president and its officers among its members. Okay. Quite simple. Let's think about this in more detail then. The president of the European Parliament is elected from the members of the European Parliament. So these are known as the MEPs. So a president of the European Parliament will be one of these members, and like it says here, will be elected from this pool of members of members of the European Parliament. And the president will serve for half of a parliamentary term. So, given the fact that Article 14 of the TEU outlines a parliamentary term as being 5 years, a president serving half that time means that they serve 2.5 years. So you have 2 presidents per parliamentary term. They will be the primary representative of the Parliament when it comes to negotiations and conversations with other members of the European Union, i.e. when it comes to other institutions. So where there are negotiations and conversations that are had between the Parliament and the Commission, or the Council and the Parliament, etc., etc., it will be the President that spearheads the majority of these various kinds of conversations and negotiations. They are also the person who gives the green light to documentation on behalf of the Parliament itself. Now, given all of these factors in terms of the composition and structure of the Parliament, what do the powers of the Parliament entail? Well, according to Article 14, the European Parliament is given the power to amend, adopt, or reject the European Union's budget. So it has quite significant financial controls over the other institutions, should I say, of the European Union. And this is reflected in the fact that the European Parliament is directly accountable and directly elected by the people of the member states of the European Union. It makes sense to suggest that they will have a lot more authority when it comes to the budgetary and financial decisions that are made by the Union with the taxpayers' money that is given to the Union by the member states. This is a power that is shared in conjunction with the Council of the European Union, and the procedure for adopting and establishing the EU budget is outlined in more detail in Article 314 of the Treaty on the Functioning of the European Union. So the TFEU outlines the general procedure for which an EU budget is established. This is a basic overview. What will happen is the European Commission will draft a provisional EU budget, which will then be sent to both the Council of the European Union as well as the European Parliament. The Council will then adopt a position on the budget before sending this information to the Parliament. The budget then goes through a number of stages within the Parliament itself, and also within the Parliamentary Budget Committee, before being, if it is agreed, it is adopted by the Parliament and therefore adopted as the official EU budget. If it is rejected, then it means that the whole process must begin again, with the Commission submitting a new draft budget with relevant amendments attached. Now, when it comes to the relationship between the Parliament and the Commission, this is arguably the most important legal power of the Parliament. It has the ability to hold the European Commission to account. This is outlined in Article 234 of the Treaty on the Functioning of the European Union. What Article 234 says is that if a motion of censure on the activities of the Commission is tabled before it, the European Parliament shall not vote thereon until at least 3 days after the motion has been tabled, and only by open vote. If the motion of censure is carried by 2/3 majority of the votes cast, representing a majority of the components of members of the European Parliament, the members of the Commission shall resign as a body, and the High Representative of the Union for Foreign Affairs and Security Policy shall resign from the duties that he or she carries out in the Commission. They shall remain in office and continue to deal with the current business until they are replaced in accordance with Article 17 of the TEU. In this case, the term of office and the members of the Commission appointed to replace them shall expire on the date which the term of office of the members of the Commission obliged to resign as a body would have expired. What is this essentially telling us? Well, it gives us the ability for the Parliament to essentially resign and deliver and issue a motion of censure to the Commission and therefore look to appoint a new Commission, which is incredibly important and an incredibly influential power that the European Parliament has. Welcome back, everybody, to our studies of the law of the European Union. In this lesson, what we're going to do is talk about the European Council. So we're continuing our examination of the various different institutions of the European Parliament. We've talked about the Commission, we've talked about the Parliament. We're going to talk about the European Court of Justice in the future lessons as well. And this lesson, like I said, is going to focus on the European Council, some of the treaty law which essentially establishes the powers and the regulation of the European Council, as well as some of the processes by which voting takes place within the European Council as well. Essentially, what we did in the previous lesson was look at the structure, functions, and powers of the European Parliament. This lesson, we're going to do the exact same thing, but looking at the functions and structures and powers of the European Council instead. So, as a basic introduction, the Council is described as one of the key political institutions of the European Union. So what does this essentially mean? Well, it means that essentially what the Council will do is have the ability to direct the policy of the European Union, i.e. looking at the different kinds of policy directions that the European Union may go in and the ways in which this policy can be implemented within the various different institutions of the European Union. Its powers and functions are outlined in Article 15 of the Treaty on European Union, which we will get to in a second. But just as a very brief overview, therefore, when we talk about the kinds of institutions of the European Union, we have to think about the ones that have and bear some relevance to us as law students, as lawyers. We are talking about the law of the European Union, which means, of course, talking about institutions such as the Parliament and also the Commission and, of course, the European Court of Justice. But then there are also the political dimensions of the European Union as well. It is inherently a political institution. It is a political, legal, and economic institution. And so as a result of which the European Council plays quite a heavy role in the direction of policy of the European Union. And this is exemplified by Article 15 of the Treaty on European Union, because it says the following, and I quote, "The European Council shall provide the Union with the necessary impetus for its development, and shall define the general political directions and priorities thereof. It shall exercise legislative functions." This gives us two major elements. We have the political directions, the general political directions of the European Union, which is defined by the European Council as per this provision, but also it notes that the European Council has various legislative functions as well that go alongside this. The European Council shall consist of the heads of state or government of member states, together with its president and president of the Commission. The High Representative of the Union for Foreign Affairs and Security Policy shall take part in its work. This is just essentially giving us an outline of the members of the European Council. It is made up of the heads of state or heads of government of the member states of the European Union, and this is done in conjunction with the President of the European Council as well as the President of the European Commission. Part 3 says that the European Council shall meet twice every 6 months, convened by its president. When the agenda so requires, the members of the European Council may decide each to be assisted by a minister, and in the case of the president of the Commission, by a member of the Commission. When the situation so requires, the President shall convene a special meeting of the European Council. So this part is just exactly how stated, is examining and outlining the process by which the European Council will meet. It shall meet at least twice every 6 months, so an average of once every 3 months, give or take. And this is a convening done by the President of the Council. Except where the treaties otherwise provide, decisions of the European Council shall be taken by consensus. We'll get to that in a second. Part 5 says that the European Council shall elect its president by a qualified majority for a term of 2.5 years, renewable once. So you are able to have essentially 2 terms as president of the European Council. Similar to, for example, in the US, the president has 2 terms as well. You can renew your term once. In the event of an impediment or serious misconduct, the European Council can end the President's term of office in accordance with the same procedure. So in the same way that the European Council will elect its President by qualified majority, that same European Council can dismiss a President by qualified majority if there is, for example, an impediment or a serious misconduct which is performed by the President. Continuing on, the President of the European Council shall chair it and drive forward its work, shall ensure the preparation and continuity of the work of the European Council in cooperation with the President of the Commission and on the basis of the work of the General Affairs Council, shall endeavour to facilitate cohesion and consensus within the European Council, shall present a report to the European Parliament after each of the meetings to the European Council, etc., etc. There are other elements that can be cited here. I'm just trying to summarise Article 15 as quickly as possible. But this gives us a number of different things. It gives us the general policy direction of the European Council, essentially what the European Council ought to do, how it ought to operate as a political institution, driving forward policy of the European Union. It also outlines quite a significant number of powers that are given and granted to the elected president. The elected president, which is done on the basis of a term of 2.5 years, which is renewable once and is done by a qualified majority. The President of the European Council, like I said in the previous slide, and as stated in Article 15, is elected by the members of the European Council, and this is done by the process of qualified majority voting. The newly elected President will serve for a period of 30 months, so specifically the amount of months that they can exactly they can serve for, they can run through. And the President of the European Council is also an EU-only rule. So what does this essentially mean, an EU-only role? Well, it essentially means that where a new president is elected, remember that members of the European Council derive out of the heads of state or heads of government of member states. But when a new president is elected, that individual who is then elected as the president of the European Council is no longer able to serve as a representative of their member state. This gives them essentially EU representation only. They are only going to represent the European Union as well as the Union's political and policy driving interests, which is an important thing to note, specifically when we're talking about the role of and the interrelationship that is had between the institutions of this supranational organization of the European Union and the member states who form the membership of the European Union as well. In this lesson, we're continuing to talk about the various different institutions of the European Union for the purposes of our study within European Union law. In the last lesson, we looked at the European Council, and in this lesson, what we're going to do is talk about the Council of the European Union. Two different institutions, I would like to add. In fact, there are, as I mentioned in earlier lessons, in fact, three different quote-unquote European councils, if you will. There are two that are associated with the European Union, and then there is, of course, the Council of Europe, which is associated with the European Convention on Human Rights. Not very easy to understand for law students, but this is just something that you have to get your head around quite early when studying European law, is that there are three different councils. This lesson, as I said, is going to talk about the Council of the European Union. We'll talk about the general role of the Council, we'll talk about the powers of the Council, and we'll talk about the configuration of the Council before finally examining the President of said Council, in an effort to essentially define and outline the main powers and functions of the Council of the EU. Like I said, and like I will make one more mention of now, is that we will delineate, and we have to delineate, between the Council of the European Union and the European Council. These are separate institutions within the EU, and both of these are separate to the Council of Europe, which is a non-EU institution entirely. So let's begin then by talking about the Council of the European Union. It is the main European Union institution which is said to represent the main interests of the member states. So this is supposed to have the member states' interests in mind when making and deliberating on decisions. Just like with the previous institutions of the European Union, the powers and functions of the Council of the EU is found in the Treaty on the European Union, specifically in Article 16. So Article 16 says the following. It says that the Council shall, jointly with the European Parliament, exercise legislative and budgetary functions. It shall carry out policy making and coordinating functions as laid down in the treaties. So it has a dual authority in relation to the kinds of powers that the Council of the EU has. So it exercises legislative and budgetary functions, and it does so in conjunction with the European Parliament. The Council shall consist of representatives of each member state at ministerial level, who may commit the government of the member state in question and cast its single vote, depending on the member state. The Council shall act by way of qualified majority, except where the treaties provide otherwise. So this is just talking about who represents members of the Council of the EU. So it shall consist of representatives from the ministerial level of the member states. And then secondly, the Council shall act by way of qualified majority. This is just explaining to us what the kind of voting system is when we look at the treaties and we look at the ways the Council of the EU makes decisions. And it says that this will be qualified majority unless the treaties provide otherwise. So if it's expressly stated in the treaties that unanimity or a simple majority or a supermajority may be required, then this is really where we see a change in the voting patterns and voting structures. I'm going to skip towards the end of this provision, given that there are some elements in the middle that aren't entirely too relevant for our purposes, and we'll just go down to Part 7, because Part 7 says that a committee of permanent representatives of the governments of member states shall be responsible for preparing the work of the Council. And then finally, the Council shall meet in public when it deliberates and votes on a draft legislative act. We'll get to what those are in future lessons. To this end, each Council meeting shall be divided into two parts, dealing respectively with the deliberations on Union legislative acts and non-legislative activities. So, if you want to know the powers, the functions, the authorities, the structure, and the voting within the Council of the European Union, you can look to Article 16, where it outlines all of this in great detail. And so when we think about this and we start to unpack Article 16 in more detail specifically, we'll begin by looking at what the configuration of the Council may be, sometimes described as the Council of Ministers. The reason why is because it is made up of the ministers of member states. So it is made up of members from each of the individual EU member states who have ministerial status, who are at a ministerial level. It will also exist in a number of configurations depending on the particular policy agenda that is on issue as an issue at that time. So given the fact that ministers and individuals within politics who have ministerial authority will have ministerial authority within a particular policy area. So you might have a minister for health, or a minister for defence, or a minister for education. These essentially ensure that the configurations of the council will depend on the particular policy agenda. So depending on the particular agenda at the time, we will see a particular set of ministers who will make up the Council of the European Union, or the Council of Ministers. Now, there are 10 in total different policy areas for which the council may be concerned, and these 10 are as follows. You have employment and social policy, at which point, if that is the configuration of the council, it means that the ministers of member states who are responsible for employment and social policy will chair and be members of the council at that time. You also have transport, you have justice, you have environment, education, economic affairs, competitiveness, agriculture and fisheries, foreign affairs, and general affairs. So, generally speaking, what the configuration of the council does is outline quite a significant number of policy areas that any government should be concerned with. So every government should be concerned with education, with the economy, for example, with environment and justice, and foreign policy. And then they also add in a couple of ones which are still unique and important to member states, but also provide something of a unique and importance to the European Union. owing to the role and the competences that the European Union has. So, for example, agriculture and fisheries actually is something that is very important for the European Union because it has spent a lot of time developing its law, EU law, on agriculture and fisheries, with things like the Common Fisheries Policy, for example. So, if the agenda pertains to employment and social policy, as I've mentioned, it will be composed of ministers on the issue of employment and social policy, and that's how we really get some specialized situations where we have specific policy issues being at hand, and the agenda being on a specific area of policy being dealt with and deliberated by specific ministers within those areas. Finally, then, the President of the Council. So the presidency of the council will be held by every single member state and will be done on a rotational basis. And the term of the presidency will be 6 months, and so as a result, and by basic simple arithmetic, the number of presidents per year will be 2. You'll have 2 member states who hold the position of president each year. Each member state which holds the presidency has the ability to set the policy agenda for their 6 months in control. So, for example, if France retains the presidency and then they become the ones in charge for the next 6 months, then it is up to France to make a determination, or it is up to the president of the council at that time, who would be a French minister, to essentially set the agenda for that particular period. So for the 6 months, maybe France decides that justice is on the agenda, and so as a result, the configuration of the council will be as such, and it will be dealing with issues of legislative and budgetary authority relating to things like justice. So in this final lesson, talking about the institutions of the European Union, what we're going to do is focus on the European Court of Justice, which makes sense. We're studying EU law. The Court of Justice is one of the most important institutions of the European Union for the legal implications and the legal principles that it hands down. Just like with all of the other lessons that we have done where we've examined the various different institutions of the European Union, we'll talk about the Court of Justice in terms of what the treaties say about the Court of Justice, the Treaty on European Union, for example, talk about the various different competences that the Court of Justice has, as well as the powers and authority, the structure of the court, and the way in which the court operates. As you can probably imagine, as I've mentioned as well at the start of this lesson, the European Court of Justice is one of the most important institutions for anybody who is studying European Union law. When we study European Union law, one of the major elements of EU law is the cases that is handed down by the Court of Justice of the European Union. So we'll get to those in future lessons' time, but for now, in terms of examining and highlighting the importance of various institutions, the Court of Justice for a law student is one of the most important. So, the Court of Justice of the European Union is sometimes described as the Court of Justice of the European Union, and is the ECJ-EU, and is made up of a number of judicial institutions. Okay, so the Court of Justice of the European Union is a little bit more of a multifaceted judicial institution. There is the Court of Justice itself, the ECJ, okay, and then you also have the General Court, because of course there are multiple different institutions of, or at least of judicial institutions. Because there are multiple instances of judicial institutions, though, this does not suggest that this is an appeals court. The Court of Justice of the European Union is not an appeals court. So where we look at domestic legal systems, like in England and Wales, for example, you see that there are various different appeals courts that take place. You have the Court of Appeal, and then you have the Supreme Court at the highest level. The Court of Justice of the European Union is not that. It means that cases are heard in other jurisdictions will not be able to just simply appeal to the ECJ if the ruling is not in their favour. Instead, like judicial decisions in domestic courts, the Court of Justice of the European Union is a first instance court. Okay, so you will go to the European Court of Justice to uphold the law of the European Union. It will hear cases which are brought specifically and directly to them, so with the intention to bring it to them, not as a final last resort or an appeal from previous judicial decisions. Most of the time, however, the Court of Justice of the European Union has cases brought to it by other institutions of the European Union. So, for example, and as we've mentioned in previous lessons, the guardians of European Union law, the European Commission, will often bring cases and litigation against member states to the European Court of Justice. This is why, if you were to open your textbook of EU law, say you've got Craig and Burca, for example, and you look on the front pages where you have a table of cases and it lists all the cases that are discussed in that textbook, you will see that a lot of them are the Commission versus a particular member state. And that is the reason for that is because the Commission often brings cases to the European Court of Justice against often member states. In terms of the structure of the court, there are 27 judges who will sit on the European Court of Justice. These will be supported by the work of 11 advocates general. So they are essentially bolstered by further advocate generals who will support the judges in the work of the court itself. Now, the general structure and role of judges is provided by and outlined by Article 19 of the Treaty on European Union. Article 19 says the following. It says that the Court of Justice of the European Union shall include the Court of Justice, the General Court, and specialist courts. So as I've mentioned, the Court of Justice of the European Union is almost the collective term for a number of individual courts which exist in and around the institutions of the EU. So the Court of Justice of the European Union refers to the Court of Justice, the General Court, and any other specialist courts which could also exist. And it shall ensure that in the interpretation and application of the treaties, the law is observed. Member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law. The Court of Justice shall consist of one judge from each member state. It shall be assisted by advocates general. The General Court shall include at least one judge per member state. So similarly, just like the Court of Justice, the General Court, which is also a part of the Court of Justice of the European Union, shall also have at least one judge of a member state. The judges and advocates generals of the Court of Justice and the judges of the General Court shall be chosen from persons whose independence is beyond doubt, and who satisfy conditions set out in Articles 253 and 254 of the Treaty on the Functioning of the European Union. They shall be appointed by common accord of the governments of the Member States for 6 years. Retiring judges and advocates general may be reappointed. So this essentially is getting into the details of the appointment process for new judges to the courts of justice or the General Court. They would have to be independent, so there is a maintenance of judicial independence as essentially to be able to adhere to the rule of law. And then there are also provisions that are set out in the Treaty on the Functioning of the European Union, which give us the conditions that are required for a member, for an individual, to be appointed to the Court of Justice. They will be appointed by common accord of the governments of the member states for 6 years. So the terms in which judges actually sit are for 6 years, and then you may be reappointed if you are retiring after that period of 6 years, if you so wish, and the member state wishes you to do so. The Court of Justice of the European Union shall, in accordance with the treaties, rule on actions brought by a member state, an institution, or a natural or legal person. This gives us the jurisdiction of the court, at least the people who are allowed to and able to be heard by the court. So this is a court that will hear cases from a multitude of different individuals and institutions. It can be brought by a member state. A member state can go to the European Court of Justice. It can be brought by a European institution. Most often this is the Commission, or it can be by an individual person, a private individual, legal or natural person. The Court of Justice will also give preliminary rulings at the request of courts or tribunals of member states on the interpretation of EU law or the validity of acts adopted by the institutions. They will also rule in other cases provided by the treaties. So these are essentially the powers of the European Court of Justice. Now, because we're studying EU law and we're talking about the legal principles of the European Union, it is actually the case that we're going to be talking about these in more detail as we get to the substantive law itself. So in the next few lessons, we'll talk about EU competence, we'll talk about the lawmaking process, we'll talk about the sources of EU law, and we'll talk about the legislative process specifically. And then we will get into the ways in which the Court of Justice will uphold European Union law by and through things like preliminary rulings, before we then start to talk about the ways in which EU law is upheld in the domestic systems of the legal of the member states, so through principles such as direct effect and indirect effect, for example.